Let's go to Iman in Wimbledon. Iman, good evening.
Hello, good evening. Right. My question is that we are looking at pursuing a medical negligence claim for a family member where there could be a number of different defendants comprising of NHS trusts and even maybe an individual or two. When approaching firms for a no-win, to see whether they would represent us essentially on a no-win, no-fee claim, one consistent theme we came across is that the firms have said that if we professionally recommend that you should, after having got into this, that you should drop the case at any stage, or that, it's not worth pursuing, then that's fine. You don't pay a penny. However, if you as the client pull out from your side when we still think, that the case has prospects, then you are potentially liable to pay our fees.
Yep.
One particular firm has said that they will not have that. Essentially, they say that you as the client are free to pull out at any point. We are willing to take that as a risk. Should we decide to go ahead with this one firm who is offering that option, what should we make sure we get from them in terms of written contractual wording or anything else to say that, down the line, should we pull out, we're not liable to pay a penny?
Iman, that is a great question. It's very, very common in no-win, no-fee agreements for the agreement to say, if you pull out and we think still think it's a winnable case, you've got to pay our fees up to date. And you get why solicitors want that, because they'll have done loads of work for free and they expect to be paid. If you change your mind about litigation, that's your right. But if they've done all the work, they should be paid for it. And I get that. So I'm surprised but impressed that you've persuaded a firm to waive that standard clause. You just need to make sure that's what the contract says. There'll be terms and conditions they send you, and you just got to make sure you've got to read those terms and conditions in the letter of engagement. Make sure that's what it says and that's reflected there. And if it's not, get a letter from them saying, as a condition of us engaging your services, us being you and your family, as a condition of us engaging your services, we have agreed, and this takes precedence over your standard terms and conditions, that if we decide to pull out, you will not charge any fees. That's all you need, Iman.
Yeah, it's not only their fees, it's also, along the way they may have engaged experts and what have you.
Oh, my goodness. Are you sure they've agreed to this? This sounds extraordinary.
Yeah, this one firm, all the other firms say that no, we cannot work on this basis. One firm has agreed, and the thinking is that medical negligence case could last a few years if you've got a sick defendant. That person, it's a stressful case. The stress of litigation may get too much for them. Something may change in their life. It's an option we want to have, basically, for those reasons.
Yeah. Iman, amazing. Absolutely incredible negotiation there, getting that. I've never heard any firm agree to that before. Well done. I think I've answered your question.